Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you are enjoying our content, please remember to subscribe and hit the notification bell to get notifications of all of our uploads. Today is a fun one. We've got a whole bunch of fun people suing a whole bunch of other fun people. We've got a former Teen Mom 2 star who appeared on the 8th season of 90 Day Fiancé, as well as an attorney for another 90 Day Fiancé star, suing some YouTube bloggers. This is the case of Amber Sherrington and Young One University et al. Versus John Yates, Tarina Cheryl of Cheryl World. In this case, a whole bunch of people are suing a whole bunch of other people related to defamation. It's hilarious. So we're going to read this lawsuit, read what people are being accused of, read about some people maybe being fired from podcasts, call some girl shit and some other things. That's the name of the podcast, and all kinds of fun things happening in this lawsuit. Let's learn a little about it. Let's get started with this. The plaintiffs are seeking injunctive relief against defendants for persistent and dilatory actions and statements made against the plaintiffs, and defendants have refused to curtail their activities and statements despite having been given a cease and desist. So despite being told to stop, the defendants won't stop. So we want an injunction to make them stop. How exciting. All right, so one of the first issues that we have to solve, because we have a whole bunch of people being sued in this lawsuit, is jurisdiction. So this will be familiar to our friends from Without a Crystal Ball, KJ World, about personal jurisdictions. We have a whole bunch of people. We're trying to sue them in Utah. So the question is, can we sue all these people in Utah? So we're learning a little bit about this, but I'm sure there will be some thoughts from the defendants on this issue. But let's learn a little bit about, can we sue these people here? Also, one might wonder why Utah, but upon information and belief, this court has jurisdiction over defendants Yates, defendant Lloyd, defendant Cheryl World, defendant Sanders, and Jane and John Doe's 1 through 20, based on continuous and systematic minimum contacts through distribution and targeting of Utah in online content, and have caused injury in the state despite notice. So some of this language may seem very familiar from our discussion from Without a Crystal Ball, right? So distribution of online content, causing damage in Utah, so some of this language should seem familiar. We're like, I'm not so sure about those minimum contacts. Further, upon information and belief, the defendants have committed tortious acts within Utah. If that were true, then we'd be solid. And or have committed tortious acts without the state of Utah and engaged in persistent court of conduct derives revenue. I don't know about that one. So we have personal jurisdiction under the long-arm statute. Yeah, so one of the issues I can see right away is jurisdiction. And, of course, we have to discuss jurisdiction for each of them individually. So can all these people be sued in Utah? I don't know, but I have my doubts. If they've actually committed acts within Utah, then that would be great. End of analysis. But, I don't know. We'll see. But so that will be a fight, I'm sure, about the jurisdiction issue. Okay, regardless of whether or not we can sue them in Utah, we have to decide what we want to sue them for, right? So what bad stuff apparently happened? Let's learn a little bit about the stuff that allegedly happened. Okay, so as to Plaintiff Richardson and her husband allowed defendant Yates and his husband to move to Indiana's home with them, which right away makes me think, why are we not suing in Indiana? Right? Why are we suing in Utah if the home is in Indiana? But let's press on. During an encounter with Yates, he threatened Richardson, stating that he would file a false report to Child Protective Services against the plaintiff and her husband, and would make a false claim of abuse and neglect. In February of 2020, the Ogden Dunes Police Department appeared at their home, stating they had received a report, and they were there to investigate, and later afternoon, CPS arrived stating they received a report of abuse and neglect. Don't let the police in the house would be my recommendation. Don't let CPS in the house either, for that matter. The CPS is the government, just like the police. And they say, we're here to investigate. It's like, that's nice. Do you have a warrant? No? Okay, well, I'm not going to let you inside my home. Well, we can go get a warrant. Okay, go get one. Come back. Let me know. On or about February 17th of 2020, Plaintiff Richardson filed a police report against Yates and issued a trespass warning against Yates. On or about February the 28th, Yates aired or broadcasted a live stream, interactive program on YouTube where defendant Yates and his audience discussed topics live and how he allowed them to make comments while on air that were subsequently reported and posted. Defendant Yates proceeded to release private information against Richardson and discuss not only allegations he levied against her, but also telling fans to call CPS and the police department and report claims against Richardson. Yeah, that's a no-go. You can't, unless those people have independent knowledge to make the complaints, they can't make the complaints because they don't have independent knowledge. When you call on people to call the police or call Child Protective Services, no, right? You can't just say, call the police. The people have to have knowledge. So if these Child Protective Services are just getting random calls from people, no, that's a no-go. You can't do that. No. Defendant Yates released a video on Instagram stating that Richardson was harassing Yates and accused her of neglect and abusing children and having a drinking problem and a drug problem, which is untrue. Yates accused Richardson of attempting to forcibly have intercourse with his husband, of having an affair with another man, and also publicly doxed his husband's place of employment and residence. One wonders why they were let into the home in the first place, but that's neither here nor there, I guess. Plaintiff Richardson discovered that Yates had created a blackmail email account to store information about prior to Yates' tenancy. Yates went live on YouTube in another attempt to discredit Richardson. Yates admitted online in a YouTube live video that was subsequently posted to YouTube that they gave another fan information to call the police department, and a second user information to call CPS. You can't do that. You're now getting people to make false reports to CPS. The reports are false even if the underlying information is true, because you're telling people here's what to report, right? If you have information to report to the police, by all means report it, right? But if you are telling people here is what you say, you're asking them to make a false report because they don't have knowledge, right? The report is false even if it has underlying truth to it, because they don't know those things. If you're feeding it to them, that's a no-no. You can't do that. Also, it's illegal. So all kinds of problems we're alleging here. As to plaintiff Drexler, defendant Yates doxed Drexler's wife, showing that she worked at the Mayo Clinic in hematology and oncology, and called plaintiff Drexler a racist and questioned his wife's political views on white supremacy. I'm not sure if it counts as doxing if you're showing that she works at the Mayo Clinic. I'm assuming by showing, we mean that information is publicly available on the Mayo Clinic's website. So I'm not sure that counts as doxing. During the same period, Yates threatened Drexler by stating that he would hate for anything to happen to him or his wife or companies they manage. Depending on how that's said, that might be kind of a threat, kind of extortion, right? Be ashamed if anything happened to your business, right? Is that an expression of concern or is that a threat? Depends on overall context, but, maybe. During the same period, Yates released Drexler's image on Instagram, or released his full name, and video where he claims Drexler is racist against persons of color. Always with the charges of racism. That is like the go-to these days. So if you don't like someone, just accuse them of racism, right? So yeah, that's a problem. You can't just make up stuff. You can't just say, well, this person, you can't just make things up. That's not going to fly. During the same period, Yates released Dexter's wife's name and photograph, her work address and location, and asked followers if they wanted to report her to the Mayo Clinic, asked them to report her husband was racist, and describe how they made them foul. So we're going full-bore cancel culture here, basically is what we're saying. We're going 100% full-bore cancel culture. We are encouraging people to report them to Child Protective Services, report them to the police, report them to their employer, to spread accusations and rumor. We are going full bore 100% cancel culture on this one. So depending on the truth of some of these things, these may be problematic, to use language from the left. This may be problematic. This may be, in fact, illegal. So yeah, this is not, depending on whether or not this is true, some of this stuff looks really, really shaky for the defendant. On March 31st of 2021, so we got recent stuff happening, Yates posted to YouTube, that was subsequently posted, with Trancy Canzaro, and talked about plaintiff Eason's dismissal from her podcast. Defendant Yates called Devian Clegg, who said she was at his kickoff event for the Girl Shit podcast, and defendant Yates said plaintiff Eason was let go from the podcast. Defendant Yates said it was brought up to management and was enough for Eason to be fired, which was untrue, and be affected Eason and her business opportunities because Yates had made a false statement about business and prospective business. So now we're like saying, oh, someone was fired from a podcast when that wasn't really true. Okay. On or about April the 1st of 2021, Yates went live on YouTube and subsequently posted a video on YouTube with defendant Lloyd and defendant Cheryl World. Defendant Yates said that Eason had claimed she was not fired and was in fact a producer, which was true concerning Eason and her role on the Girl Shit podcast event. So we're making false claims about someone's business. Well, we're saying they're fired. Oh, in fact, no, I wasn't fired. I'm actually a producer. So making false claims there. On or about April the 1st, Yates went live on YouTube and subsequently posted on YouTube and said, all he could say is the rumors came out at the same time. A certain person got fired from the podcast and her name rhymes with Reynold Pevens, plaintiff Eason, which again is false information. Yeah, that's not going to save you, incidentally. If people can readily determine who you're talking about, giving them a fictitious name doesn't help, right? I'm really talking about my friend Bob. Let me talk about my friend Bob. He has all these qualities. And people are like, no, you're talking about Steve. No, I'm talking about Bob. No, you're talking about Steve. Okay, yeah, giving them a fictitious name, or like, if people can readily determine who you're talking about, no. And also, their name rhymes with. I don't know what strategy you were going with, but that's just not valid on any level, no. On or about April the 6th of 2021, Yates went on YouTube live with defendant Lloyd, defendant Cheryl World, and defendant Sanders, and made statements regarding Kenton alleged business fraud when Kenton received a Paycheck Protection Program loan from the Small Business Administration for a daycare. Okay, so now so this is being broken up by each plaintiff. So we're showing the relationship. Incidentally, this is well drafted. I like the drafting on this, right? So we're showing how each particular plaintiff has been harmed by each defendant, and now whether or not they are related or not could be a point of controversy, right? So can all these plaintiffs can they all bring cases against all these defendants? The answer is probably yes, but it's not for certain, right? Because the cases are somewhat distinct. But yeah, if every plaintiff has a case of action against every defendant, can they all bring cases at the same time? Can they consolidate like that? That might be a question. Or to use a more proper language, is this proper joinder or improper joinder? Have these plaintiffs and these defendants been properly joined? So that could be a fight. Also, jurisdiction is going to be a potential fight because we're suing them in Utah, and it's not clear, at least obviously, that any of this stuff has anything to do with Utah. It might very well. It's not obvious. I did see someone's home, like in Indiana or something. It's like, well, we have jurisdiction there, probably. Can we haul these people before a Utah court? Don't know. But I see a joinder fight in the horizon. I see a personal jurisdiction fight in the horizon. But I do like the way this is being drafted. It's like, here's every plaintiff's thing. Here's all the things that the defendants have done against them. So if we need to sever it for any reason, it makes it a lot easier on the court. And the court's going to appreciate that no matter what happens. It's like, you made it easier on me, thank God. So I don't have to untangle this. You've done it for me by just a little bit careful drafting. It makes it so much easier. You've made the judge's life happier and easier. Thank you. I can say the judge is already saying thank you in their head, I'm sure, no matter what's going to happen, right? Okay, so as to Kenton over here, we want to make allegations of fraud relating to the PPP loans. Defendant Lloyd went live on YouTube to discuss Kenton and adding it was a preview for tomorrow's broadcast because it's a big story. And Kenton had been defrauding the government. How Yates, Lloyd, and Sanders need to discuss these phony loans. So the loans are fictitious. All right. Lloyd and Sanders' headline for the YouTube was, Andrew Kenton's daycare is defrauding the government. Well, that's pretty much a factual claim. That's pretty factual. Andrew Kenton daycare is defrauding the government. That's pretty factual, man. Not a lot of opinion there. And the amount of controversy would be felony. During the stream, Yates, Lloyd, and Sanders revealed the PPP loan documents and his address and falsely claimed that Kenton had created the daycare for the purposes of the loan. All right, so that is the allegation these defendants made, right? Kenton doesn't really have a daycare. Kenton doesn't really have a daycare. He created a fictitious daycare for the purpose of getting these loans, which, as you would imagine, if true, is very illegal. But it's not true, at least according to the plaintiff, who is going into court and saying that's not true. You know, I don't know where this daycare was. Maybe it was at his house, which might be legal. I don't know the nature of the daycare law in the relevant jurisdiction. Neither do you, for that matter. So maybe it's at his house. Maybe that's legal. Maybe that's illegal. I don't know what's going on here, but in any case, he says, yeah, I really did have a business. I got a PPP loan. I qualified. I got the loan. So apparently these people are talking well out of school. And he wants to sue because, remember, the episode was entitled, Andrew Kenton's daycare is defrauding the government. That's a pretty strong factual claim. It's a claim of moral turpitude. It's a claim of crime. It's a claim. It's a bad. Yeah, so that's actionable. You know, maybe you don't accuse someone of defrauding the government unless you're sure. It sounds like, yeah, that's not going to fly now. All right, let's press on some more. On or about April the 7th, Lloyd and Sanders went live on defendant Cheryl World's YouTube channel and repeated the claim, claiming Kenton and the daycare would defraud the government by making false statements on the loan application, which could be a felony offense. So so we've made the statements, we repeat the statements, we're accusing us of felonies. That's not going to fly. That's a problem, yeah. Okay, how about plaintiffs Sherrington, Amila, and Crosby? Defendant Yates streamed for 28 minutes on his YouTube channel concerning these people. The videos received 4,550 views on YouTube. Yates has made false statements alleging Sherrington had Jaihoon Line app login and Instagram login, and she was texting online celebrity Devin posing as an online celebrity. So I have false credentials for an account, and I'm talking to a celebrity. Yates falsely stated every time money was low, Sherrington would threaten Jaihoon to go live on YouTube to raise money to defraud the public. Yates alleged that Sherrington and Amila had formulated this plan prior to the launch of a Jaihoon GoFundMe account, and Lloyd would provide additional information. Yates further alleged that Sherrington would boast to others she'd been watching DVN for a long time, claim she lived next to her, and may or may not have been stalking her, which is again a criminal offense in Utah. Yeah, depending on what exactly we mean by stalking. But yeah, the word stalking, incidentally, and this is kind of a little bit, it depends how the term is understood. Because the term stalking, at least in a criminal sense, has a very defined meaning. And the people talk about stalking in a colloquial sense versus its criminal sense. And the crime of stalking is significantly more narrow than the common understanding. And by significant, I mean the details are significant. Like the gradation, the total magnitude may not be significant, but it's significant in so much as it matters. So people's understanding of what stalking is and the reality are not the same thing. So I guess first thing we'd have to determine is, by stalking, in what sense are we using the word? Are we using it colloquially, or are we using it flippantly? So it's like it depends. Are we using it flippantly, like we don't even really mean it? Are we using colloquially, we mean it, but we're not using it with precision? Or do we mean it in a legal sense? So yeah, how exactly are we using the word stalking could become a fight here. So yeah, depending on exactly what you're doing, it may or may not be criminal, or it may not be stalking from a variety of vantage points. So, you know, we'll look past that for the moment, because that could be a fight about exactly what we're talking about. Defendant Yates also said the title of the GoFundMe account had changed 3 times, and the plaintiff were defrauding people in the amount of $16,000, which is a felony offense in the state of Utah. I assume that's true. And it was directed specifically at Amelia's professional license and JCA's business and prospective business. Defendant Yates indicated the money for Crosby, Charrington, and Amelia and JCA made from PayPal was $16,000, but estimated it was actually closer to $20,000. So he says the amounts that are traceable are 16, and I think it's closer to 20. Those are claims of fact. Defendant Yates claimed that Charrington had naked pictures of Deviant up on her page and referred to plaintiff Amelia and JCA when she stated that these are low-class lawyers. Low-class lawyers, unfortunately, a matter of opinion. As much as I wish it weren't true. Unless, of course, we're saying that because we're alluding to privately held facts, in which case it's not a statement of opinion anymore. Yates further stated on YouTube that Charrington, Crosby, and Amelia were shady as F. Again, it depends how that's understood. Are we basing that on facts? If so, are they hidden facts? Is that understood to reveal facts? That could go a whole bunch of different ways. In chat comments during Yates's live podcast, someone pointed out misappropriation of funds will get an attorney disbarred. Preach that. That's about the number one way to get disbarred as an attorney. Misappropriating funds. That's pretty much number one on the list. It's not lack of fiduciary duty. It's not even lack of fiduciary duty in terms of like being a good lawyer. Those things won't hurt. Those things won't help. But if you want your punch your ticket express lane to disbarment, I stole the client's money. Yeah, even more so than I revealed the client's secrets, even more so than I shouldn't have taken that case. I wasn't competent, even more so than just about anything else. I took the client's money. You're on the choo-choo express train to disbarment on that one. Yeah, I remember Leonard French told a story one time around these lines, and he didn't cheat anybody, but he told a story one time where because of some technical issues dealing with money coming in and out of ITOLA accounts, that there wasn't quite enough money to clear a check. And he got a notice from the bar. And it wasn't like they were investigating him, but he still panicked. Because just to let you know, we noticed that, the bank told us that there was a short on the ITOLA account. And he still panicked because, he knew he was in the right and stuff and he didn't do anything wrong. But because of how big a deal it is, it's like you panic a little bit inside. I understand. I've never gotten that letter from the bar, but if I ever did, I tell you what, I panic too. It's that's the number one express trick too. You want to get that clear right up. So yeah, if you're accusing a lawyer of stealing from their own client, oof, man, that's a rough one. On or about April the 17th of 2021, Yates went live on YouTube with an online celebrity, Alicia Clegg. When Yates streamed for 1 hour and 50 minutes, that's rookie hours. 1 hour and 50 minutes, that's rookie hours. And as of April 26, 2021, Yates' episode had amounts 4,400 views, which isn't that many. Are we doing a Streisand effect thing? Because I feel like at this point, we're exposing way more than this ever did in the first place, but okay. It all came out in April 7th when Jaihoon posted that he owed his attorney an additional $11,000. Jaihoon said that? Okay, well, if he's saying that about himself, then I'm not sure why that's a problem necessarily, but all right. Maybe I'm missing something here. On the same April the 17th episode of the YouTube live broadcast, defendant Yates indicated he wanted plaintiff to pursue him because he understood that a lawyer must write a cease and desist letter. No. And then if defendant Yates broke the cease and desist, then people must give the attorney thousands of dollars to come after him in court. Okay, no. First of all, an attorney doesn't need to write a cease and desist letter. It depends on your state. So how about that? We'll clarify further. There are some states in which you have to give an opportunity to cure. So a cease and desist, and if you don't, certain damages may not be available. So there are mitigation laws that exist. So a cease and desist letter might actually be required, depending on your jurisdiction or not. So you can't just say a lawyer must write a cease and desist. It depends. And if they don't, it may not mean that they don't recover at all. It might mean they recover less. It depends, right? So, yeah, does a lawyer have to write a cease and desist? I don't know. Where are we? Maybe. Then if they broke it, people must give attorney thousands of dollars to come after him in court. Yeah, that's probably true, unless it's contingent. One way or another, lawyers do like to get paid. That's true. Yeah. On April the 17th of 2021, defendant Yates used his live broadcast to provoke and encourage online followers to take action with comments as, "Whoever lives in that state, call the bar." Oh my God, we're going after we're going after a bar. We're going after a lawyer's license. Okay, no. All right. Again, you can't just crowdsource complaints to the police, to the bar, to child protective services, to anyone. If anyone has a complaint, they can bring their own complaint. You can't feed a complaint to someone else. That's a false complaint. Even if it's underlyingly true, it's still false because it's not theirs. They don't have the information. So, call the Bar Association, man. That's just mean. On or about April 18th and 23rd, Amelia and the plaintiff received 2 negative online reviews by people who did not contract or not represented, and negative reviews were in fact false. So we're getting some false reports on Yelp or whatever. The reviews appeared after Yates told followers to file reviews and complaints to the Utah State Bar, and both were done at the behest of Amelia and JCA by attempting to reduce revenue. Okay, so we're getting people to file complaints to the Utah State Bar, specifically. That is looking like a jurisdictional proper thing to now my idea of now I still think you could fight the jurisdiction. I don't think it's a give me. But if you're telling people specifically, hey people, I want you to file complaints to the Utah State Bar, right? You've basically appointed everyone as your agents. And you're kind of responsible for that. So the jurisdiction in Utah is looking better. I wouldn't say I'm sold, but this is the kind of thing that is like, yeah, you are now doing something specifically in the relevant jurisdiction. You are telling people to file complaints, false complaints in Utah. That is a tort. It's a tort. You're asking someone to file a false complaint in Utah. You are now committing torts in Utah. You are directing those people to commit those torts in Utah. The jurisdiction in Utah is looking a lot better. Not saying you can't fight it. I'm just saying I'm a lot more sold than when I started this thing. Because now you're directing people to do specifically things in Utah that constitute torts. So, yeah. So the Utah jurisdiction's looking a lot better. On or about April the 23rd, defendant Drexler received complaints on his professional license at the Florida Department of Agriculture, where false allegations were made against the license, and later required to attend a hearing to discuss the false reports made against him and his business. No. On or about April the 20th, Yates, Lloyd, and Cheryl's World, Sanders, went live on Cheryl's World for 1 hour and 25 minutes. The broadcast has amassed 3,600 views. Defendant Lloyd claims that she knows how attorneys work. She was a paralegal and a court reporter. And if my attorney was on the phone with a client for 5 minutes, as soon as he hung up, he billed her for an hour. Anyone who works in the legal field knows that that's how attorneys work, which is defamatory attack. Well, if he billed her for an hour, well, it depends. It depends why he's billing her for the hour. It depends, right? The phone call unto itself can't justify an hour. It would justify a 6-minute bill because lawyers bill in 6-minute increments. It's industry practice. So a 5-minute call would get billed at 6 minutes. For that matter, a 2-minute call would get billed at 6 minutes because lawyers work in 6-minute increments, as I just said. So if he bills for an hour, the question would be why, right? What else is he doing with the time? As a result of that call, did he go and do something for his client? Did he write a memo, or did he do some legal research, or did he do something with regards to the file? So is it inherently unethical for a lawyer to charge an hour if the call is 5 minutes long, not if there's 55 minutes worth of stuff. Yeah. So why is he doing this? But no, that's not standard practice. Although I can definitely see it being fairly standard for a lawyer to write down more than the phone call, because that phone call compelled me to do stuff. Or yeah, that makes sense. So yeah, no, that's defamation though. On the same YouTube live, Lloyd further alleged the billing is total disbarment right here. That's, yeah, which directed plaintiff as a professional license. Yeah, again, if a lawyer was really doing that, if a lawyer was really taking every 5-minute call and billing them as an hour, that would be cheating the client, and that's a pretty good way to get disbarred in a hurry. Yes. I mean, especially if you're padding your bill that much, yeah. But you're saying you told disbarment. It's like, I hope you know what you're talking about, especially since you're speculating. You like, this is how attorneys in general work, which isn't really true. So this is how this specific attorney works is even less true. Yeah. Defendant Yates has persisted in false claim Kenton was defrauding the government and submitted false PPP application documents. Lloyd, Cheryl World, and Sanders joined Instagram Live where Yates was similarly participating by phone or StreamYard, an online chatting program. Defendant Kenton joined Instagram Live and asked Lloyd if she in fact stated that Kenton had defrauded the government, to which Lloyd said yes, and it's true. That would be a factual claim. Lloyd and Sanders responded to Kenton, I said what you did was immoral, and then persisted in the statement. Immoral would be a statement of opinion. Defrauded is not. So those are definitely different things. So that brings us to the end of the complaint of the case of Amber Sherrington, Young One University et al. Versus John Yates, Cheryl World et al. So in this case, a whole bunch of people sued a whole bunch of other people for some defamation and other related things. And what we can observe from the complaint is, first of all, it's well drafted. It's well organized. It makes understanding it very easy. So good job on drafting this. There's that. So props right away. It's well drafted. Second of all, some of the stuff looks very, very sketchy at best. And there seems to be some problems here. Now, I can imagine defenses. And if you can't imagine defenses, you're not trying very hard. The most obvious one, of course, is public figure. Right? But that doesn't necessarily get you past the threshold for all these things. I think some of these things you could get past public figure on. So public figure is obvious. Underlying truth, maybe. Or, depending on what's going on. For some of them, maybe. Also, there's a jurisdiction issue. Also, there's a joinder issue. So there's definitely things the defense can do here. But on the whole, it's a pretty well-written complaint and seems to allege some stuff that might survive the test of time. So we'll have to see what happens and how this develops. It's a little bit early to project how it's going to end based on what we got going on here. I think the plaintiffs have some options. And then, of course, I don't even know if the Utah has a slap or anti-slap. So there's that factor. There's a whole bunch of things that could happen. So we're nowhere near the resolution of this case, but at least until the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.